Hi everyone, welcome to our data protection webinar dedicated this time to data subject rights, data subject request, and as you will see, more particularly about the case law of the Litigation Chamber of the Belgian Data Protection Authority. As some of you maybe already know, my dear colleague, Bastian, Liz, and Pauline. Liz and Pauline will also be speaker today. Have analyzed lots of the decision of this chamber on this topic, and they have published in September an impressive article about 4 years of case law of the Litigation Chamber. So between May 2018 until May 2022. That's published in this periodical, so tijdschrift Privacy and Persoonsgegevens, and I can only recommend you the reading of this article. But no stop with the promotion of their article. And it's time now for some practical information before starting this webinar. First of all, if you wish, you can download the presentation. On the right hand side, under Handout, you can download it. Second, during this webinar, there will be 3 poll questions. You will see they are quite easy to answer, I think, for your organization. They are not too legal this time. After the webinar, you will receive a certificate from GoToWebinar attesting that you duly participate. And last point, from the practical information that I think it's really useful for you too. If you have any question, there is a chat box, so do not hesitate to ask your question via this chat box, and we will answer your question by email after this webinar. So let's start. Why did my colleague decide to examine and analyze so many decisions, more than 100, about this topic, so data subject rights? As you know, data subject right is something really important. It was something that was already important under the directive and the Belgian privacy law of 92, but with the GDPR, the protection of the privacy and the amount of right for data subject increased, and there is no in the GDPR one specific chapter related to the right of data subject. So chapter provide for 8 rights that we will discuss in detail in this webinar, and we will discuss this based on the case law of the litigation chambers. The data subject rights is something really crucial, not only for your organization, but also for the authority and the Belgian Data Protection Authority. If you read its strategic plan management plans for the 5 years, one of the main topic and one of the focus of the Belgian Data Protection Authority is clearly data subject rights. As you know as well, in case of non-compliance with GDPR and the provision on rights of data subject, there is a risk that your organization can be sanctioned by the Belgian Data Protection Authority, and among the sanctions there is the possibility of fine. As you know, the amount of the fine can be quite huge, but so far the Belgian Data Protection Authority did not issue so big amount, so it's good to be subject to the Belgian Data Protection Authority. So a short overview of these 8 data subject rights. First of all, right to information. The right to information is that as a data controller, you have to provide certain information about the data processing to the data subject, and you will provide such information via a privacy policy, a privacy notice, for instance. It's something that is really proactive by a controller. So you will, in principle, as a controller, never receive a request for a right to information. Second right, a right to access. It already exists. It's something that it's not new, but we will see that it's the right that it's the most requested by the data subject, and yeah, as a controller, you will have to provide certain information and certain personal data about the data subject. We will see if you have to provide a copy of your file document, or if it's enough, for instance, to provide only personal information, personal data. Right to rectification, not new neither, as the name said, is the right to obtain a modification about data that are no longer accurate, for instance, or that not correct in a system. For instance, if someone moved, that person has a new address, and he can exercise his right to rectification. Right to object is when a data subject decides to oppose to a data processing, and the controller has to end such processing. For instance, if a data subject decides that he do no longer want to receive newsletter, direct marketing advertisements. Right to restriction, we will see not the more used by data subject, maybe because data subject do not really know, understand it, but it's the right to obtain the freezing of a processing during a certain periods. Right to data portability, so it's the right to have or your contract and your personal data, for instance, transfer from one controller to another. Right to erasure or right to be forgotten, as the name said, it's the right to obtain the deletion of personal data. As we will see, all these rights are not absolute rights, and sometimes exception can be invoked by a controller to refuse the right to access. And last right, it's the one linked to automated decision making. As a data subject, if you are, if a decision is rendered based on automated decision making, you have a certain right to human intervention and right to discuss, for instance, the decision that has been taken automatically. So that was a short overview of the different rights. What's new with all this? What we have seen when we analyzed also all these decisions is that with the GDPR, it's no easy to file a complaint before the Data Protection Authority, and that there is an increase regarding the number of complaints. We also have noticed that data subject request and issue with exercise of data subject right constitute the second largest category of proceedings before the litigation chamber. The first category is linked to legal grounds, but this demonstrates the numerous issues with data subject rights. And as already mentioned, there is a risk of fine or an obligation for the organization and the controller to comply within 1 month, usually with the request. Okay, now first poll question before leaving the floor to my colleagues, first Liz and then Pauline. The first poll question is how many data subject requests does your organization receive per year? So we said data subject requests generally, so not only access, but also the other like rectification, right to be forgotten, right to data portability.
All right, thank you very much, Olivia. We can continue then with the next slide. We will do the poll questions as a conclusion where we look at your answers that you have given. Then we are at the next chapter, which is facilitating data subject rights. As Olivia already said, there are 8 rights given to data subjects by Chapter 3 of the GDPR. However, the very first article of Chapter 3 does not specifically address any of these rights, but it describes in what way information should be given to data subjects and how data subjects should be facilitated in exercising their rights. I will therefore go through Article 12 and give you more detailed information about facilitating these data subjects' rights. So next slide, please. Okay. Although Article 12 does not itself contain any specific right, this article deals with how the controller should proceed in fulfilling the rights of data subjects. So this article indicates how the controller must proceed, what the time limit for doing so is, for example. In principle, the controller must comply with the request, as Olivia said, within 1 month of receiving it. It is true that depending on the complexity of the request and on the number of requests that are received, the deadline may be extended for another 2 months if necessary. So the controller shall notify the data subjects of such an extension, of course, also within 1 month of receiving the requests. Now, obviously, for the controller, he must be able to act on the data subject request. And to do so, the data controller must be able to identify the data subject. Only in the event where the data controller can prove that it's unable to identify the data subject, then the request can be disregarded. And of course, this should not be done so easily. In one of my further slides, I will give you more information about the additional measures that the controller must take regarding identity verification. And I will go more into details at that point. But Article 12 also states that complying with the requests of data subjects must be free of charge. So therefore, as a data controller, one may not charge a fee to the data subjects or bill the work hours when it comes to the rights provided for in the GDPR. But to stop any potential abuse, Article 12 does provide for an exception. So when the requests from data subjects are manifestly unfounded or excessive, such as when the data subject makes the same request for several times, well, then the controller may either charge a reasonable fee or even refuse to act on the request. It is true that requesting a reasonable fee is of course preferred, and the controller will therefore be able to ask the data subject to agree to this fee before charging it and before granting the request. The amount that is being feed should also be reasonable, of course. It is meant that it's merely a limited administrative cost which can be charged that is in line with the effort that the data controller will have to make to accommodate the requests. Of course, it will be up to the data controller to prove that the request was indeed manifestly unfounded or excessive or repetitive of any kind, and that it will charge a reasonable fee. Next slide, please. Okay, then an important element of data subjects' rights is the accessibility of the data controller. So not only must the controller communicate to data subjects who can be contacted, but case law shows that organizations must set up systems to streamline communications with respect to data subjects and to handle data subject requests. It is up to the data controller to make life easier for the data subject. So the data subject shall always be accommodated as possible. This could be the case, for example, by offering certain tools on the website or providing a contact form for data subjects' requests or just questions. And the focus here is on the simple nature of the mechanism. So, for example, case law has shown that it is not reasonable for a data controller to expect the data subject to make an appointment to make a data subject request. Well, that will not be considered as an easy mechanism and will not be facilitating data subject rights. However, it's also clear from case law that when it is inspected, while it is inspected, that the data controller should have worked out those simple systems for the data subject. But it's important that those systems are well communicated to the data subject, but also that the data subject is not really bound to comply with those systems. After all, the data subject cannot be blamed for making the request to the controller in a different way, in a way that was not foreseen by the data controller. If a data subject request ends up at an email address other than the one communicated in, for example, the privacy statement, but that is addressed to a different contact person, for example, the contact person the data subject has with one of the sales team, well, then the organization will have to ensure that the request does really reach the responsible team, being the privacy team or DPO office. Of course, the staff member cannot simply waive any responsibility by referring the data subject himself to the correct address by responding to the email saying, okay, I'm not a responsible person, please send an email to our dedicated email address. Oh no, this will have to be dealt with internally. It is therefore very important that sufficient training is provided within the organization about data subject requests. For example, through awareness trainings, through a data subject rights policy, in order that every staff member within your organization knows what to do. So staff must be explained how to recognize a data subject request, because as Olivia said, the mere change of an address is in principle the right to rectification or an exercise of the right to rectification. So it's important that staff members know how to recognize such requests, and that it's important that they know to whom they should forward this request, and as well about the timing that is very crucial at that point. So it has to be as soon as possible to a dedicated email address. Next slide, please. So as I mentioned earlier, the controller may refuse to comply with a request from data subjects when it's not possible to verify the identity of the data subject. However, this does not mean, as was confirmed by case law, that simply asking for the data subject identity card is in every case justified. It is true that the GDPR requires that additional information can be requested, but this information should always be limited to what is strictly necessary. So one of the easiest ways to identify the data subject is obviously the identity card, as shown here on the slide. However, the identity card should not be systematically requested. This has also been confirmed by the EDPB guidelines. So regarding the use of identity cards, it's important to note that not only the GDPR is applicable. So the Belgian Act of the 19th of July 91 regarding population registers also prescribes that the national register number and the photograph may only be used if authorized by law and if there is a free, specific, and informed consent of the holder of the electronic identity card, being the data subject. The Litigation Chamber has already used this wording as well, recalling that there are special rules that apply to the use of this national register number. And the Litigation Chamber states that it shall always, everyone should be very cautious of the use of this number while asking for it. So another decision of the Litigation Chamber shows that even if data subjects are requested to provide a copy of their full identity cards, the data subjects will have the right to blur all unnecessary information. This is to avoid any processing of more data than is strictly necessary for identification purposes. And in any case, a good practice is to request only the data necessary to verify the identity of the data subject. This can be done by using personal data, which is already held by the organization about the data subject, and comparing this information. Next slide, please. An important lesson when it comes to data subject rights is that as a data controller, one must do everything within its power to make it as simple as possible for the data subject. One should not expect the data subject to turn to the correct email address or to clearly state which right they want to invoke. The controller has the responsibility to set up systems, both internal and external. What do I mean by that? Make sure that data subjects can easily follow a process to request what they want. Provide a process so that right away the necessary information is requested, and the controller as well knows what to do. The organization should also take measures internally. So as I said before, make sure that staff at every level of the company knows what to do and who to contact. Make sure there are policies for this, that there is sufficient awareness training within the organization to streamline this very important process. It is also up to the controller to interpret and in some way translate the data subject's questions from a legal perspective. So as a data controller, you cannot expect the data subject when a request is made to clearly state what right is being invoked, let alone that it must include a reference to the GDPR article. Well, this will be up to the controller to translate and to interpret this request, possibly by asking questions if necessary, to understand exactly what the data subject wants. Just know, well, that any question will not extend this deadline. So any communication you might have with the data subject will not extend the deadline of 1 month. We see that the bar is set quite high for the controller. We have to say that. It's important to know what the responsibilities are and how the organization can act accordingly. Next slide, please. So far, we've only talked about facilitating requests from data subjects. However, there's a lot of case law that deals with the rights of the data subjects themselves, so the 8 rights that Olivia already referred to. I will go over these rights together with my colleague Pauline in the same order as prescribed in the GDPR. Next slide. So first, there is the right to information, which is a right that has become more prominent due to the GDPR. The transparency principle states that the controller is obliged to inform the data subject about the processing of their personal data. Well, usually this is done by communicating a privacy policy or a privacy statement. It is intended to enable the data subject to assess in advance the scope and the consequences of processing. How should that information be given to the data subject? Well, this is described in Article 12 as well. Information shall be provided in a concise, transparent, intelligible, and easily accessible form, using clear and plain language in writing or by other means. So here I return to my previous slides that said not all data subjects went to law school. Well, that is a principle that certainly is applicable here as well. The information must be given to the data subject in a way that is understandable to the data subject. The intention is, of course, that the data subject reads the information given and will become wiser from it. The Litigation Chamber has also confirmed this as well. So it's not the purpose that just a large amount of text is being sent to the data subject, but it should always be understandable. The information should not contain any terminology that is unclear to the person concerned, the person that is addressed to, so to the data subject, without any further explanation. So make sure that you use wording that is appropriate to the data subject. Of course, this is all the more true when it comes to data subjects who are minors. They deserve special attention and should go and obtain the information in a way through a medium that they can easily understand. Of course, once again, there are some exceptions to this. For example, it will not be necessary to inform the data subject again when the data subject has already been informed. In such a case, it is assumed that the data subject is already aware of this information and does not need to be informed a second time. And on the other hand, it is also true that there are examples where it would be too difficult to inform the data subject. This is often the case when it comes to information obtained directly, for example, indirectly, I mean, for example, through social networking sites or through other public publications. Next slide. So which information shall be given? Well, this is a long slide and it contains a long list of information that shall be given. So first of all, the identity and the contact details of the controller and the DPO. It is important that the identity of the controller is somehow clear. It's not the purpose to give any false impressions onto the nature of the controller being a non-profit or a public entity. This is something that we came across while studying case law. And it is useful to indicate whether an internal or an external DPO is used. Other things that should be mentioned are the specific purposes and the legal basis of processing. So you have to make the distinction between regular personal data and special categories of personal data. Secondly, this includes the public or legitimate interests that are relied upon by the controller or by a third party. Any specific legal obligation that the controller might have to process any personal data, and as well any further processing. So if it is intended to, the example is given, the mailbox of an ex-employee, something that we came across while studying our case law as well. Well, in case it is further processed, if this data is used in a way that is different from the initial purpose, this shall be always communicated to the data subject as well. Recipients also have to be informed about if there are any international transfers, the retention periods or the criteria that is used to determine this periods, any other data subjects. I'm going quite fast in this slide because a lot of this is just confirmed by the litigation chamber and is not really new to anyone. So the right to withdraw consent, of course, the right to lodge a complaint. What is important there is that you should not limit it to the Belgian DPA or the Flemish Supervisory Commission. It's important that indeed there are contact details given about for the DPA, but to leave it up to the data subject. Now, what is something that is was interesting when studying the case law is that in many privacy policies, we see that the controller states that the privacy policy may be amended from time to time. Well, the controller has the obligation to mention which changes of the privacy policy that were made and how data subjects will be informed about these future changes. This, of course, does not mean that the controller should send an email to the data subject for every change that is done in the privacy policy. However, a good overview of the versions will suffice. So then the source of personal data, where you get your data from, and as well, if there's any profiling, you should give the meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for the data subject. So this is article 13 and 14 about what information shall be given. Next slide, please. Now, we discussed what information shall be given, but now in what way should the information be given? Well, the main way obviously remains the written information through a privacy policy. If it's appropriate, for example, when it comes to the processing of personal data for a web shop, the privacy policy can also be posted electronically on a website. What is less common, but still not impossible, is the oral transmission of information. This can be done when requested by the data subject and when it seems appropriate. For example, when the personal data is obtained directly and physically from the data subject. So what is advised is, of course, to use standardized icons in privacy statements, which make it very easy for the data subject. As well, visual display. So for example, here the sign of a surveillance camera. This is something that is obliged by the Camera Act, but it's also useful in terms of the GDPR to transfer your information to the data subject in a way that the data subject understands. And then lastly on my slide before we go on is that there are several examples that were considered insufficient by the litigation chamber, where the information is not given in an appropriate way. For example, a mere press release or a publication in the Belgian official gazette, so the Belgisch Staatsblad. This was considered as not easily accessible information towards data subjects. And now we can pass on to the next slide. All right, so when must the data subject be informed? The obligation arises at the moment that the data controller receives the data, regardless of whether the data subject is aware of the disclosure of data. It does not really matter whether the data subject is aware of the processing, but the intention is to inform the data subject about such processing. This is confirmed by the litigation chamber. So the data subject will have to be informed. For example, the example given in the previous slide about camera surveillance, but also temperature monitoring was we came across in our research. So even if the data subject is not aware, he should be informed. If the data were not obtained directly from the data subject, such as through publicly available sources, the controller must communicate this information to the data subject within a reasonable period and no longer than 1 month after the data controller received this data. Of course, this is different when the controller is communicating with the data subject and is thereby using the personal data. In such a case, the information should be given immediately. And if the personal data is transferred, well, then the data subject should be informed before this transfer takes place. It is important that this information is given so that the data subject can decide whether or not he or she wishes to provide the data. This ensures that the information must also be available to, for example, future customers. In this sense, the litigation chamber stated that it cannot be that the privacy policy can only be consulted on a closed customer portal that is not accessible to any future customers. Next slide. So what do we learn from the litigation chamber case law when it comes to the right to information? Well, make sure that data subjects are, of course, easily informed. Check your privacy notices regularly, not only in terms of certain nuances given by case law or any legislative changes, but also check whether data subjects can easily access the information. So check the practicality for the data subject. Provide systems that the data subject can easily find their way to the privacy notice. In principle, a data subject can hardly be facilitated too much. So, for example, make sure that the email footer has a link to the privacy notice. So this allows the data subjects to get to all the information very quickly and in a very efficient way. Next slide. Okay, so a very important lesson learned is about the specificality of the privacy notice. So make sure the data subject is actually informed about all processing activities. This is because general wording will not make data subject any wiser. So make sure that you clearly state what data is being processed and for which purposes. If there are legitimate interests or legal obligations, be clear about exactly what the obligation or interest would be for the controller. The litigation chamber appeared to very much dislike unclear wording, such as 3 dots or using etc. Also, never say that you have other purposes for processing, for example, but be very specific, state exactly what your purposes are or will be in the future. The same goes for the type of personal data, the recipients, public entities, for example. Be very specific about what you mean while communicating to data subjects. Next slide. Then when it comes to the second right given to data subjects, the rights to access. This right, as you can see on the slides, contains 3 layers of information. So the right to obtain information as to whether or not personal data is processed by the data controller. The right to receive details about the processing, and granting access to the personal data that is being processed. So to the extent that it's a general request for access and the data subject simply states that they want access to their personal data, well, then the data controller must provide each of these 3 layers of information. The right to access is also seen by case law as an essential requirement for data protection and in some way the gateway to the exercise of other data subjects' rights. Certainly, this is very logical as it allows the data subject to know more precisely what processing operations are taking place. On the other hand, which is very important as well, it's not necessary for the data subjects to exercise any other rights. So the data subject always remains free to choose which rights are exercised. Okay, next slide, please. I will go over this again very quickly and only state what is important for the litigation chamber. So if the data subject does not really limit the requests, stating, for example, I wish to know the purposes of your processing activities. If it's just a general request, then please note that all information shall be given. It's also not only what is said in Article 15, but, for example, the legal ground for processing, if requested by the data subject, shall also be included. We see that data subjects tried to cross the line a little bit and request more than is required, but there the litigation chamber stopped the data subjects and said, for example, that as regard to data processing agreements or the data processing register, for this it will not be necessary to give access to the data subjects. Next slide, please. And of course, the right to access to personal data only applies to personal data that is related to the data subject exercising such a right. So providing access to personal data of third parties is never allowed, except in some cases of representation. Think, for example, about parents exercising the data subject rights for their child. The litigation chamber has confirmed this. The case concerned a complaint against the Federal Finance Administration for refusing to disclose the cadastral income of a real estate property of a third party, which was used to compare to the property of the complainant. So the administration had taken into account certain comparable properties when determining the cadastral income of the property owned by the data subject without wanting to disclose these other properties of third parties to the data subject. as a cadastral income or the value of a property, the address, as this is clearly personal data as well. Well, the complaint was also dismissed by the litigation chamber, and it was reminded that the GDPR expressly provides for an exception from a copy of personal data if the disclosure would prejudice the rights and freedoms of others. However, even though granting the access request shall not adversely affect the rights or freedoms of third parties, there are many situations where personal data of the data subject is somewhere tied with other personal data of other data subjects. So controllers must thereby avoid to refuse the right to access just because there's third-party data involved, but should do whatever is necessary to balance really both rights to of the data subjects and of the third parties. So once again, the litigation chamber provided some guidance in this regard. One of the cases concerned an ex-employee that requested access to his personal data, including notes or comments that are part of a personnel file. The employer refused to comply with the request, stating that this would violate the rights of the employees who wrote such notes in the personnel file, being it the manager or the HR department. And the litigation chamber stated that the rights to obtain a copy of data does not mean the rights to obtain a copy of the original document containing the data, since, well, in some cases, the communication might prejudice the rights and freedoms of others. So the controller may protect the rights of others by anonymizing their personal data contained therein. And it's in principle, we can say that it's sufficient that only the personal data contained in the document will have to be provided to the data subject. In another case, the litigation chamber states that the fact that the right to access may not infringe on the rights or freedoms of others, this may include trade secrets and intellectual property rights as provided for in the GDPR, while as applied by the litigation chamber in a certain case, a controller may refuse to provide a copy if it considers the risk of improper reuse of that copy to be too big, and if one of those parties has already used the records in a way that violates a confidentiality clause, for example. If a choice must be made by the controller in such a case between the rights to provide access or the rights to data confidentiality, well, priority then must be given to the confidential nature of this information, and the right to access may be limited. For example, also according to the litigation chamber, a data controller may refuse to provide a copy of all emails to a former employee when these emails contain the identity of the customers, of invoices, and that the employee has already in the past wrongfully disclosed business secrets to third parties. So in this way, the right to access can be limited. Next slide, please. And then we come to a very, what I would say, a sensitive issue, because in practice we see that some data subjects are using the GDPR as a certain tool to achieve another purpose. So, for example, to obtain more information, not just about the processing of their personal data. And in such cases, well, fundamental rights are actually being used or abused to serve for another purpose. And the question thereby rises, like, one, can the controller take this into account? Can the controller refuse to grant access because the controller suspects that the data subjects have objectives that go beyond their privacy rights? Well, this is a very interesting topic, and the litigation chamber has already ruled on this. in principle, the purposes of the data subjects when requesting access would never matter. So it would be irrelevant that the data subject uses the right of access to obtained information through somewhat a backdoor. This was the case of a former employee that wanted to use the right to access to obtain records relevant to a lawsuit against his dismissal. Well, this is obviously a difficult position for the organization, for the employer. Nevertheless, there's already some nuance given by the litigation chamber as well. And it actually, in other cases, rejected the use of the GDPR to achieve another goal. So the litigation chamber has already ruled that it's not permissible for data subjects to abuse the right to access to when they have a their real motive was to find out whether or not a tax investigation was being conducted. Well, the privacy and concerns in that case were quite limited as well. As I said, that it's something that would likely be recurring more frequently in the future as data subjects are knowing more what their rights are. They're becoming more aware of which rights they are given to by the GDPR. So we expect that there's a lot to be said in the future about this data protection as a weapon, and we are very curious to see how the litigation chamber and the market court will balance this difficult situation. And then something that is also mentioned on my slides is that the limitation of the right to access when it would require an unreasonable effort on the part of the data controller. For example, the litigation chamber has already ruled that it's not reasonable that an ex-employee would have to examine all IT logs throughout the entire employment agreement, which was for more than 10 years. According to the litigation chamber, the complainant, the ex-employee, had not explained the importance to him about those IT logs in the request. It had not filed any briefs or did not return to the litigation chamber after receiving the briefs of the employer. So the litigation chamber saw no specific interest to justify the large workload that would constitute a systematic search in the context of this request throughout all IT systems about all data concerning this data subject. Well, the case is not only interesting to read just for the disproportionate nature of the request, but surely that the litigation chamber has also recognized that the individual, the data subject, cannot just ask for anything without providing any context and for proving the importance in this case. Next slide, please. And then I come to my last slide. It leads to our conclusion for controllers that receive a right to access. Well, be critical where needed. I discussed it several times. I gave several examples where the controller should not provide access to the data subject just because, for example, it might infringe rights of third parties, it is repetitive, or it could place an unreasonable burden on the controller. Therefore, it's important to communicate with the data subject. This does not only apply to the rights to access, but to all data subject rights. Show your commitment to the data subject and ask some questions if necessary. That way you can learn more about the data subject's reasoning for making the request. Be sure to also check to require more information, check your files to see what might, if something else might be going on. Make sure to keep track of your records. of your to keep a record, to keep track with a record of the requests that you obtain, not only to fulfill your accountability as a data controller, but also to check whether the same requests has already been complied with in the past. So create such a register in which you can keep track of data subjects, the category of personal data that is being requested, and the reason for this request. And then we come to a next poll question that we have. So from whom did your organization receive the most data subject requests? Is that from customers or ex-customers? Is that suppliers? Is that employees? I've given the example multiple times already, or ex-employees, or is that from other data subjects? And with this poll question, I give the floor to Pauline, who will give more information about the other data subject requests and rights.
Hello everyone, so indeed I will take the floor now, and I will start by talking about the right to rectification. Now, as you know, the GDPR contains several main principles, and one of these principles is the accuracy principle, which is, at least in my opinion, a very important principle of the GDPR. And so this means that the controller has an active obligation to make sure that the data that it holds of its data subjects is accurate and that it's also complete. But if the controller fails in this obligation, or it doesn't fail, but the data subject feels that its data are not accurate, then it can ask the controller to complete information about the data subject, or it can ask the controller to correct incorrect data. Now, of course, there's this discussion about what accuracy means. What is accurate data? And so there we have some cases of the Litigation Chamber and also of the Market Court that are based mainly on the landmark cases of the European Court of Justice. And so there's data that may change over time. And so there, a data subject may ask a controller to change its name or change its address or change its banking account. For example, if you want to read about the banking account case, there is a case of the Litigation Chamber, which is the case 2022. So it's a very recent case where the court applies this regarding a bank account. And it's also, in this sense, important as a controller and also for the personnel of the controller to be aware that when a customer contacts the customer service center to say that its address has changed, well, this is actually a data subject request where the requirements of Article 12 that Lisa discussed should be respected. So, for example, the controller has to answer within a month, for example. So very important here to train your personnel to recognize an exercise of a right to rectification. Now, for these data that I mentioned, it's pretty obvious if the data is accurate, yes or no. It's a yes or no question. It's a factual question. However, for some data, it's harder to determine if the data is inaccurate. For example, a notarial deed, there the Litigation Chamber has stated that a data subject may not ask to correct data in a notarial deed because the data has changed over time, because when the notary verified the information that is in the notarial deed, it made sure that the data was accurate at the time, and so it's not appropriate to ask sometime later, maybe years later, to correct the data because it was accurate at the time. So this is not an issue of accuracy. Then also a medical diagnosis. This is a case that was overturned by the Market Court. In this case, a doctor diagnosed or made a diagnosis regarding working capacity of an employee, and the employee did not agree with the diagnosis of the doctor, and hence exercised its right to rectification. And there the Market Court stated that the right to rectification was not the appropriate right, or was not a tool that could be used to change a medical diagnosis because it's an expert opinion and it's not a fact that can be inaccurate. That's one thing, but on the other hand, the Market Court did recognize that if there is a material error, for example, in a medical file, then of course this can be corrected through a right rectification. Now, what is also, I think, very important in practice is that this is an obligation of result. So if a data subject asks you to correct its data, you have to correct the data. And if you do not correct the data, you're liable or you have infringed this right rectification. So using your best efforts, it's not enough. You have to correct the data. This is based on a case of also the Market Court of 2019, where a person asked to correct its name to a bank because its name had an accent in it, and the name that was used by the bank did not contain the accent. And there the bank stated that changing its IT systems to be able to include accents would take a lot of work, which was unreasonable and not balanced with the rights of the data subject. And there the Market Court did not agree with the interpretation of the bank, and so cost what it costs, as you say in Dutch, the bank had to change its IT systems to be able to allow that right. There's another decision, for example, the decision 30/2022, where the tax administration is also not respecting the right rectification of a taxpayer that had notified its change in marital status to the tax administration, but the tax administration failed to take this change in marital status into account for the next tax applications. Now we can move on to the next right, which is the right to erasure, or as we often know it as the right to be forgotten, following the Google Spain case of the Court of Justice. And the right to erasure is the obligation of the controller to delete data or erase personal data if it's asked by the data subject. Now, if the controller has made this data public or has maybe communicated it to other controllers, or obviously also to data processors, well, there the controller must take reasonable steps to inform the subsequent controllers and sub-data processors as well to delete that data. And we see here on the slide, it says take reasonable steps. So here, this is an obligation of means. It's not an obligation of results, contrary to the right to rectification. And so, as I said, the controller must inform the recipients of the data that the data subject asks to erase its personal data. Now, of course, in the online environment where information can lead its own life and can propagate very easily everywhere, there's also the issue of search engines that will link to certain data. And even if the underlying information is deleted, these links may still be in place, or the information might have been taken up. And so there, it's important that the controller takes the necessary steps to delete these links, and so to comply with the right to erasure as much as possible, as stated before, to take the reasonable steps. In this case as well, it's important to inform the data subjects of the steps that you're taking and to be transparent, because by being transparent, you are giving back control to the data subject, which is the objective of this right. Now, here the French Data Protection Authority and also the Litigation Chamber has recognized that these reasonable steps do not mean that you have to delete all search results all over the world, because this would be impossible and would be an unreasonable operation. We also see this right to erasure applied in the decision of the Litigation Chamber of 2020, the decision 64 of that year, where an ex-employee or an employee left the company, and the company kept all his emails for a long time and also kept the email addresses active. And there, that person exercised his right to erasure, and there the Litigation Chamber also indeed said that the former employer had to delete the emails and had to delete the email address as well. And so if you're in the case of an employee that leaves and there's still the email address and you're not sure what to do with that email address and what to do with the emails of that former employee, I recommend to read this decision, because there the Litigation Chamber sets out practical guidelines on how to deal with this matter. Now, also with something which is, I think obvious, but was repeated by the Litigation Chamber, is that the request for erasure must be made to the controller and not to the data processor. It's the controller who is controlling the data, who is responsible for the data and accountable, that must make the decision and that must erase the data. And so here, this is a case also from this year, the case 25 of 2022, where a data subject asked an IT contractor that was repairing its computer to delete data. And there, this was not appropriate because the IT contractor was just a data processor, and so it could not make any decisions regarding the right to erasure. Go to the next slide. The right to erasure must be acknowledged to the data subject, and data must be deleted without undue delay when one of the following grounds applies. So this is in the law, data is no longer necessary, and there's a case, also the case 64/2020, where the email address of a former administrator or employee is not necessary anymore. The data must also be deleted when there is withdrawal of consent and there are no other legal grounds applicable. I think this is also obvious, and I mean, follows from the main principles of the GDPR. The data must also be deleted when the data subject objects to the processing, and we will talk about the right to object later, and there are no overriding legitimate grounds to keep having the data. And the data must also be deleted when it has been unlawfully processed. Also seems pretty obvious. The data must also be erased when it's necessary for compliance with the law. You also have to be careful when there is data processed by a child by an information society service provider. Now, there are some exceptions. In our practice, we often receive questions regarding these exceptions to the right to erasure, or at least the controller does not want to delete the data, and so it asks us how it can refuse the exercise of a right to erasure. And so here the law provides some exceptions because, as Olivia said, the rights under the GDPR are not absolute rights. First of all, the right to erasure may be refused when it's not in balance with the right of freedom of expression and information also of society. Here we have 3 bullet points that we added based also on case law of the Litigation Chamber. First of all, we have a case, the 38th case of 2020 regarding a lawyer who had been convicted for several crimes. It doesn't state in the decision what the lawyer was convicted for, and so it asks several years later that the data about him being convicted would be deleted online. So this was a request made to Google, and Google there refused the request. So there was a complaint submitted to the GBA. And the data subject argued that the data that was put online was not relevant anymore because he had changed careers. He wasn't working as a lawyer anymore. He wasn't working in that field anymore. But there, the Litigation Chamber decided that the information regarding his past, his criminal convictions were still relevant for society, and that people who were looking for a legal expert still need to have access to that information and to be informed about what happened in the past. Then we have another complaint, 37/2020, the case of the Litigation Chamber, where again there is a complaint made against Google because a person in the past, a person had been accused of bullying. This was 10 years before the case, so the information was 10 years old. And so that person asked that the links towards articles or internet website mentioning these accusations of bullying would be deleted. And here, contrary to the previous decision, the Litigation Chamber indeed decided that the information regarding the bullying was not relevant anymore, and so the right to erasure had to be admitted. And so Google had to delete the information. What is also relevant here is that the accusations of bullying were found unfounded. And so they were unfounded and they were 10 years old. So here, indeed, the information had to be deleted. Then we have a final case regarding online archives. This is the case 139 of 2021. Again, it's a bit awkward. Again, a lawyer who had been convicted for criminal offenses, doesn't state which ones. And these criminal offenses, these proceedings had been covered by press articles in the past. I think it was in 2015, 2014, so it wasn't that old yet. And so the lawyer in question, or legal expert later on in his career, asked a national newspaper to delete from its archives articles relating to his convictions and the criminal offenses he committed. And he stated that the information was not relevant anymore, he changed careers, and so this information should be deleted. And there, the litigation chamber decided that no, his right to privacy was not more important than the right to freedom of expression and the right to information of society, and maintaining these articles in the online archives are still relevant. Something that played here as well is that the lawyer in question was a public person, and so he could have expected that press articles would be made regarding his criminal offenses. Now, key takeaways, of course, if you are admitting a right to erasure, this right must be permanent and irreversible. So you cannot afterwards try to obtain the information again. As stated before, it should be a well-considered right, because as I stated, when the information is deleted, it should be deleted and there is no access to the information anymore. As I stated before, when we receive questions of clients regarding this, often they may be scared that in the future there may be a legal claim or there may be a legal procedure. And if the information is deleted, well, there is no proof anymore for the future procedure. However, I'm not talking about this in this seminar, but the application of this exception is very unsure in Belgium. As I said before, there's also, you have to pay special attention when parents or adults are asking to erase data of underage children. Only a person that has parental authority can ask to delete data. And as stated on the slide, how to determine who has parental authority, for this you have to look into the Belgian Civil Code. And also interesting, the litigation chamber added here that the deletion must be in the best interest of the child. So you, as a controller, can ask the data subject or the parent of the data subject to motivate why it is asking the deletion of the information of the child. Now we also have on other case, for example, regarding Facebook, where a data subject communicated with a company through Facebook messages, and there it asked to delete its data, and here the company deleted this data within a month, or deleted at least these messages, and there the company deleted or granted the right successfully and was not reprimanded. And also, a very important, this is the last bullet point of the slides, the right to erasure is an obligation of means, but it does mean that the controller must use its best efforts to delete all data of the data subjects in its systems. And so a superficial research is not enough, and the data controller must make sure that all data regarding that person is deleted. Here I am referring to a case also of this year of the Litigation Chamber, the case 39 of 2022, where a data controller stated that it had deleted all data of the data subject, but it had not deleted an old email address of the data subject. And there the Litigation Chamber stated that it could have found the information in its system and its research was not sufficient. Now let's go to the next right. This is the right to restriction of processing. I think we can go over this right a bit faster because there's no case yet, treating this right by the Belgian Litigation Chamber. So if you want to apply this right, I recommend to look into case law of other data protection authorities of the other member states. You can use GDPR Hub, for example, to easily find these. And so as the time is running short, I propose that we just go to it a bit more quickly. And so as I stated, it's still uncharted territory. There is no decisions that interpret or that add anything to this right other than what is in the law. So there are two decisions that we have found that do mention Article 18, but they don't add anything new. And these are the decisions 46, 2022 and 66, 2021. Now let's go to the right to data portability. This right is a new right that was added to data protection law by the GDPR. And the idea behind it is to make data subjects less dependent on a certain service provider or a certain controller. And so it can give you the right, for example, if you're not agreeing with the takeover by Twitter by Elon Musk, to change your data or ask Twitter to export your data and to transfer it to a new social media platform that would have equivalent functions. This only applies this right when the processing is based on the legal grounds consent or a contract, and when the processing is carried out by automated means. So if data are only processed on paper, for example, this right does not apply. Let's go to the next slide. Now here we have a use case. This is a case of the Litigation Chamber. It's the case 2 of 2021, and it was afterwards overturned by the Market Court. But in this case, there was an artist that had a contract with a manager, I think, if you read the decision, and the manager was managing the fan page of that artist on Facebook. And so there are some issues, and so the artist wants to retake over its fan page, which has its full name and is clearly for that person. And so here, indeed, the Litigation Chamber decided that the manager or the controller had to indeed grant the right of data portability and had to transfer the fan page and the admin rights of the fan page to the artist. Now, in this case, it's a bit of an unlikely or peculiar application of the right to data portability, and this is not what was foreseen by the legislator, but I mean, it can be used in other ways. And what is also important here is that there was a contract between the artist and the manager that stipulated that the manager had rights to manage the fan page, but here the Litigation Chamber stated that the fan page, or I mean the contract, could not override data protection law. So also, I think something very important to take in mind. Now, the key takeaways of the right to data portability, as also stated by Lisa in the part regarding Article 12, so facilitating the rights. This is also a right that must be facilitated, and so you must grant the right without hindrance. So you have to make it easy for a data subject to exercise this right. Now, there are two exceptions where you can refuse to grant this right to a data subject. One is when the processing of this data or this data is being processed for a performance or a task carried out in the public interest. And also if you you're exercising official authority as a controller. Another exception that is not written on the slide as well is that you can refuse to grant this right when it would adverse rights and freedoms of others. Now let's go to the right to object. The GDPR foresees the right to object in several use cases. First of all, you can a data subject can object to the processing of data when the data is carried out in the public interest, or when the data is processed under the legitimate interest of the data subject. Now then, the controller has to grant this right to object unless it can provide compelling legitimate grounds, that override the interest of the data subject. Now, there's also the right to object to processing at all times when the data of the data subject is being used for direct marketing purposes. And we will see that all case law that we have found regarding the right to object concerns this use case for the direct marketing purposes. For example, there is the case 13 of 2021, where a data subject objected to the use of its data for sending direct marketing messages through SMS. Now, what is very important about this right to object is that you must give, again, control to the data subject. And so the data subject must be aware of its rights to object. So you must provide the information regarding the right to object at the latest, at the moment of the first contact with the data subject. And the information regarding the right to object must be clear or separated from other information. So it cannot be comprised in the bulk of the text. You can maybe use a little box and put it, a red box, put it around the right to object, so that a data subject directly, its eye directly falls on this information. We have some use cases regarding this direct marketing. There is the case 71 of this year, where the NMBS, SNCB, which is the Belgian National Railway Company, was sending direct marketing emails to a data subject without informing the data subject about its right to object. And there the NMBS was reprimanded by Litigation Chamber. And here there was a lot of discussion, of course, about the concept of direct marketing. What is direct marketing and what is not direct marketing? There was also a case, the 19th case of 2021, where Telenet, a data subject, made a complaint regarding Telenet because the right to object with Telenet was hidden on the platform My Telenet, so the user platform, or a data subject had to call the call center, or even crazier, I think, you had to make an appointment to go to the store and there exercise the right to object. And so here the litigation chamber said that this was not acceptable. Performing the right to object should be as easy as providing the information. And I think we can here also refer to the press, or the press today, where we saw in the standards today where there were questions regarding the direct marketing proposed by KBC this week in its application. So we will see there what the litigation chamber says regarding the practices of KBC. Now, as I said, the objection must be as easy as providing personal data, so you must be transparent, and the objecting must be practical. So you cannot ask a data subject to make an appointment in the store, for example. And so a one-click system could be advised in this case. Let's change to the next slide. Then we have the last right. Again, I'm going to go over this quite quickly because I see we're running out of time, because the Belgian Data Protection Authority has not been presented, I guess, with any complaints regarding this right. And so there's no case law to our knowledge at this moment regarding this right. So I will go over it because everything that is here is directly stated in the GDPR. I think, yeah, as I stated here, there is no jurisprudence of the litigation chamber at the moment regarding this right. However, with the rise today in use of AI and machine learning to automate processes, to save time of human beings, I would say, or because machine learning may be more efficient for some use cases, the exercise of this right may become more important in the future, and we may have more use cases in the future. So in here we have, so as I said here, there is no, you cannot subject someone to automated decision making when it concerns special categories of personal data, for example, medical data, unless one of these three exceptions apply. And I think now I can give the floor to Olivia to provide you with a conclusion.
Many thanks, Pauline. Before going to the conclusion, sorry, I made a small mistake. I would suggest to deal with the third poll question. So then I will be able to summarize the answer to the three poll questions. So the third poll question is, have any data subject request received by your organization led to proceedings before the Data Protection Authority? Okay, so now we are at the end of this webinar. I think now you receive a lot of tips and tricks and a lot of information to help you to answer to data subject request. And I think that based on this, you will be able to easily deal with these question and about complaint before the Belgian Data Protection Authority. At least I hope this will be so. The result of the poll question are that depending, I assume, of the size of the company, the sector of activity, or especially whether you are dealing with a lot of less personal data, I would say that the half of the participants and the half of the organization that participate today only have to deal with a few data subject requests a year, less than 10. So it's really a low amount, and good, I would say, for you. But there is also 24% of the organization that have to deal with more than 100 data subject requests a year. And for this organization, for sure, you need to be well organized, to have a policy in place, a specific process, and as well a good register, because for sure, more you have to handle with this request, more the risk, I would say, is high that there is then a complaint. Regarding the second question and the second poll question, the results are quite clear, and we could, I would say, expect them in a way. 56% of these requests came from from consumer or ex-consumer, and 25% come from employee or ex-employee. There is no request coming from a supplier, and there is also 18% coming from other. It would be nice to know who are these 18%, but based on the decision that have been discussed today and that we have examined, it was clear for us that there is really a trend that most of the complaint before the Data Protection Authority come from consumer, ex-consumer mainly, or ex-employee, especially regarding the right to access, right to erasure, or right to object. And last question, have you already been before the Data Protection Authority due to a complaint for a data subject right? And there, the answer to the question is that only really a few of you have already had the occasion to deal with this, and I would say it's quite positive. Maybe less for us, but for you, for sure. And this could also demonstrate that the things that you put in place in your organization are quite good. So that's positive things. To one last word regarding this presentation. So the watchdog, the Belgian Data Protection Authority, as you have seen, is more and more active. The number of complaints increase, especially regarding data subject requests. You have also noticed that the expectation of the Litigation Chamber are quite high for a controller, but that also very often the Litigation Chamber decide first to give a certain period to the controller to remedy and to provide the information or to delete the personal data before issuing a fine. So that's quite good for controller. You will have also noticed that the decision of the Litigation Chamber are often tempered by the market court, which is also good for controller for sure. And based also on this overview of case law, there is already a lot of decision for specific rights, like right to access, but less or none for other. So there is still some room for development, and for sure that within a few years we can proceed to the same exercise and not necessarily arrive to the same conclusion, or there will be for sure a new development for you as a controller. There was a few questions that have been asked during the webinar, but since we are a little bit over time, we will reply to this question by email. You will receive our answer within the coming days. I want to thank you for your attention and also participation to our last data protection webinar of this year, and do not hesitate also to subscribe to our newsletter, because for sure we will publish within the coming months about a decision of the Litigation Chamber that might be related to data subject right or other issue like legal ground and all the provision of the GDPR. I wish you a nice afternoon and also a nice weekend. Bye.